Welcome to the latest episode of our podcast series for financial advisors. Today's episode is How to Avoid the Dreaded TRO, Legal Strategies for Advisors in Transition. It's a conversation with Jared Malone and Michael Brezen, partners at the national law firm Schumacher. I'm Louis Diamond, and this is the Diamond Podcast for Financial Advisors.
At Diamond Consultants, we help elite advisors identify the right environment for their businesses to thrive, whether that's at a wirehouse, boutique, or independent firm. With nearly 3 decades of experience, we've guided thousands of advisors and represented more than $250 billion in assets transitioned. And each year, 1 in 4 advisors managing $1 billion or more who change firms are our clients. Our process is education-driven and based on building relationships, starting as your strategic partner well before you're even thinking of a move. To schedule a confidential conversation, call us at 908-879-1002. Wondering why advisors change firms and where they're headed? Are transition deals going up or down? Those very questions and more inspired us to create our annual Advisor Transition Report. It's the award-winning, data-driven resource designed for advisors that connects the dots between the motivations around movement and the firm's appetite for top talent. Arm yourself with the knowledge you need to make smart decisions. Download your copy at diamond-consultants.com/transition report.
If you'd followed recent industry headlines, you've probably seen an unsettling trend: a growing number of TROs, temporary restraining orders, being filed by large wirehouses and firms in general against advisors who leave. It seems that firms like Merrill and UBS and Edward Jones are increasingly using TROs to restrict advisors from contacting clients or moving accounts immediately after resignation. For those caught in the crosshairs, the consequences can be serious: reputational damage, legal fees, and weeks of uncertainty at exactly the wrong time. Yet for those who are moving with guidance from attorneys who are experienced in advisor transitions and are coloring within the lines, it can seem that these legal actions are more show than substance. To help us unpack what's happening and more importantly, how to avoid becoming a headline yourself, I'm joined by Jared Malone and Michael Brezen, 2 leading attorneys who represent financial advisors and financial services firms around transitions and disputes. Their firm Schumacher has handled thousands of advisor-related cases, including defending the recent OpenArc transition from Merrill, which drew national attention when a judge quickly ruled in favor of the breakaway team. In this episode, we explore why TROs are resurfacing, which firms are the most aggressive, and the biggest mistakes that can put advisors at legal risk. Jared and Michael also share their practical strategies: how to protect yourself before, during, and after a move, and why having the right legal plan in place can make all the difference. It's an eye-opening conversation on the legal side of advisor transitions and how to make your next move with clarity and confidence. So let's get to it. Michael and Jared, thank you both for joining us today.
Thank you for having us.
Thank you.
Awesome. Let's dive in. This has been a very hot topic. We get a lot of questions about it. And I know the two of you are absolute experts in the world of financial advisor employment transitions. So that'll be the bulk of our episode today, but let's rewind the tape here. And why don't you both share your backgrounds and also, if you don't mind, sharing a bit about the law firm you work for.
I'll start. Thank you. We work with Shoemaker, Loop & Kendrick, which is a large national firm. I think we have about 13 offices around the country, about 300 attorneys. And we have a team down in Sarasota, Florida, with 15 attorneys that specialize in this area and additional support staff and paralegals. And with my practice, I focus on transition counseling, representing advisors with FINRA litigation strategy.
Great. Seems very relevant to our audience. Jared, how about you?
I do a little bit on the less of the day-to-day transition work that Michael does. Over the years, I've focused my practice more on the complex litigation side, doing some high-level things, racketeering and antitrust things that I've applied actually in the financial services space to my client's advantage. And so the skills that Michael and I have, we kind of complement each other well because we work as a team, hitting basically both sides of what needs to be done for the client.
Racketeering, that's like mafia stuff.
Yeah. Racketeer. I have used that in FINRA arbitrations many times.
All right. Maybe that'll be the follow-up podcast is how you apply racketeering and mafia strategies to financial advisors. Amazing. How did you both get into the world of advising wealth managers or folks in financial services? Was it always a passion or what led you both to our industry?
Well, with me, it was not something I ever thought about. Ended up as a prosecutor out of law school. And so I had about 30 first chair jury trials as a prosecutor doing criminal law. And one of the partners on our team, our senior partner, he was on one of my jury pools. And he's like, "Who's this prosecutor?" And he wrote a letter to the judge and he stole me from the state attorney's office and brought me here. And it was just Michael Breslin and Michael Taft, who's the one that hired me. It was just the three of us when we started out back, I don't know, 20 years ago. So, yep. Ever since then, we've gone from 3 attorneys now back then to about 15 attorneys presently with something like 7 or 8 additional staff. And when you talk about getting into this space, we were not in a national practice necessarily back then, but sometime around 2009 area, we uncovered a massive fraud that had been perpetrated by Bank of America when it acquired Merrill Lynch. We were pretty much one of the first firms to move forward on cases against Merrill Lynch for people who left Merrill Lynch. And one of the cases that we had was the Ramazzi and Smolchek case, that it was a couple financial advisors who had left and they had $250,000 in deferred comp. And we ended up taking that case on and it lasted several years. The hearing itself was a knockdown, drag out fight that lasted 3 months. And we ended up winning $10 million for those 2 advisors. And what had happened in behind the scenes is we had gathered thousands of other former Merrill advisors who were our clients. So once we won the Smolchek case, things started to roll from there.
Wow. Very interesting. Michael, anything to layer on top?
Yeah, that was a fun time. And how I got into this was a degree in finance, and I have a master's in alternative dispute resolution. So Michael Taft, the senior member of our team, liked that resume and wanted to bring me in for arbitration type work. And it was very good work. We sophisticated working with financials advisors, broker dealers, and it was just basically the 3 of us until we took on the giant Merrill Lynch, and that was over deferred compensation vesting based on the change of control. And after that big win, that was in Wall Street Journal and things like that. I think after that time, we had over 300 individual arbitrations that we had filed and needed to staff that. So we started a pipeline of really smart young attorneys from University of Florida and others coming out of school and could learn the business. And I think we went on and resolved over 2,000 of those cases against Merrill over the years. So we had a lot of experience with Merrill, especially, which we'll probably talk about the Open Arc transaction, but that really helped us understand how they work and how to deal with them. They've got great law firms, and you need to have good advice on your side when you're dealing with something like that. But we're very active here in the space at this point with this many attorneys, and everybody's busy. And we typically hire 1 or 2 every year from our program, bringing them in from law school. But we currently advise dozens of broker dealers, RIAs, corporate type clients. We have hundreds of individual financial advisor clients every year and are extremely busy nationally and even internationally. We do a lot of work for international financial advisors and things like that. So with every case, we learn more and we can apply that to our future disputes and clients for their benefit.
And let's add on to that, as a result of representing thousands of financial advisors and hundreds of arbitrations, all at the same time, by the way. This wasn't over the course of many years. This was all at once.
We're very busy.
We were very busy. We, as a result, learned all kinds of information that led us to do class actions against Merrill Lynch, against Wells Fargo, and we really grew our presence on the national stage. We started intervening in some class actions where we thought the financial advisors weren't getting enough benefit, and all of that just essentially led us to where we're at today.
It's amazing how one action or one thing just leads you to the rest of your life. That's a very cool story. I want to spend most of our interview talking about this. Kind of feels like almost like a shifting, like legal ground that we're walking on right now with TROs becoming more prominent. But you mentioned deferred comp. I'm obviously not a lawyer, that's why we're talking to you, but it feels like we're also seeing a lot more headlines about advisors bringing lawsuits against firms over deferred compensation. When advisors leave, they can't keep their deferred compensation. Are things changing on that side of things? And all these stories we're reading, is that in real time? Am I reading it right? That there is seemingly more opportunity for advisors to challenge the firms when they leave on keeping their deferred compensation?
Yeah, and I'll take first shot at that. I think there is. And what's happened over the last few years, unfortunately, Morgan Stanley had borne the initial brunt of some of this, but all of the firms are getting hit with it. And those are deferred compensation claims based on ERISA primarily. Essentially, what they're saying is that if someone lasts 3 years at a firm, the firms are supposed to pay people out under the deferred compensation plans. And California has its own non-compete laws that allow people to vest out. But as a result of that, there's definitely been a market increase in the last few years in deferred compensation type of years.
Yeah, the Merrill cases were based upon the change of control. There were actually change of control vesting provisions if certain requirements were met. And that's gone by the wayside here at this point. And most of what you see now are these ERISA actions. Some firms are resolving them. Wells Fargo resolved a large class action there. Merrill Lynch has fought the class action brought against it and had it dismissed, and that's currently on appeal. There's also opportunities in an individual type FINRA arbitration if somebody was forced out of the firm early, wrongfully terminated. That with more and more deferred comp being part of the base compensation, there's an argument there that if they're deprived of the opportunity to stay at the firm long enough to get that vested to them, then there should be some sort of equitable offsets there. So there's been a lot of cases where panels don't award deferred comp, but there's certainly an opportunity. It should be analyzed in a holistic review of the case.
Makes sense. So to make it simple, if you're let's say I'm a $3 million advisor from Merrill or UBS, pick the firm. I'd choose to leave on my own free will. I decide to go from Morgan Stanley to Merrill, and I have $1 million of unvested deferred compensation. Are those types of actions one, or this is more specific or kind of fringe reasons why the lawsuits are being won?
Well, if it was part of a class action, everybody would fall into that. But on an individual action, those can be difficult because a lot of times the deferred comp is replaced, and that's typically the firm's number one defense. You've earned it here, over there. But it just depends on the facts and circumstances. Were there other things that caused you damage? Did you have to leave the firm early from some unkept promise, things like that?
Most of the time when I see it, it's in circumstances where someone's either fired or you can argue there's a constructive discharge.
Correct.
Makes sense. Meaning like the line of business that I was operating in was no longer competitive, and I felt like I had to leave, even if I wasn't forced out the door.
Absolutely.
Yeah, we had a series of cases. Some various firms have restructured or slimmed down their international business. And, probably about 10 years ago, Merrill had significantly reduced its international business, and a lot of folks had to leave with their books and left a lot of deferred on the table. So we had a lot of claims for that group. So it's an individual analysis, but probably in the typical, you just decide to leave and go wirehouse to wirehouse. It's a much harder up-road battle in that situation.
Makes sense. All right. So I think the star of the show now is my hypothesis, which I think you guys agree with, that after several seemingly quiet years on the TRO litigation front, at least in the kind of the industry headlines, it feels like we're seeing much more of them. There's multiple TR filed by UBS in I think it was September and October of 2025. Obviously, the massive Merrill team OpenArc was caught in litigation. I know you guys have defended a lot of these. Overall, though, am I accurate that there is an uptick in TROs being filed and either granted or at least litigated?
Yeah, I think you're absolutely correct on that, Louis. The industry seems to be a little bit cyclical with this, but you're correct, especially over the last couple of years, probably certain firms have become more active. They're looking at issues that arise. And with the big increase in state and federal data breach laws, firms have to be very careful about letting any customer documents, information leave the firm and need to go recover that a lot of times. So there's a multitude of reasons for it, but you're absolutely correct. What do you think, Jared?
Well, I think after the lull, there was a lull during COVID in some of the litigation and TROs, and I think that financial advisors probably started to push the boundaries a bit on what they can do and not do because they think there wasn't as much litigation, and that goes to what Michael was saying about the cyclical nature of it all. I think that over the last few years, there's been a crackdown by firms on the confidentiality of client information, and that's driving some of it. Another thing that's probably driving is there's a market increase in transitions, I think, and then financial advisors forming and joining their own investment advisories. And as a result, the firms, they want to stem the tide a bit from people leaving. And so they're using the TROs as well in that fashion.
My non-legal hypothesis is that it makes for a great retention tool to land a advisor hub or whatever publication headline that XYZ respected advisor was TRO'd, and that's what every advisor dreads and worries about. That was my hypothesis, but it's helpful to hear too that there's maybe other reasons behind the scenes why we're seeing an uptick in such matters.
Yeah, and I don't think it's a primary driver. I think it's an ancillary benefit is probably a better way to put it. I think the primary driver is client information, but
Yeah.
Yeah, I would agree with that. And it just depends on the firm. Certain firms, UBS, Morgan Stanley, when they left the protocol, there was a lot of TRO actions that they brought. We were part of Morgan Stanley's TRO A team. We've been on both sides of these many times. And you don't see as much of that from Morgan anymore because they were very successful early on. And advisors who leave the firm typically are doing it the right way. And that's what the firms want to see. They don't want to see documents taken. If you're not supposed to solicit, then don't solicit. There's ways to transition that are within line of your agreements, your restrictions with industry rules, where you don't have to cut corners. You have to do it methodically and deliberately. And that's going to some of the recent items with Open Arc. That was a huge transaction, but there are ways to do that the right way. You just have to be very detailed with it. But yeah, there's going to be more TROs, and I think firms need to price that into deals, and individuals need to be absolutely ready for that. And a lot of the planning that goes into place is if you do something now within the transition, or how will the optics look? How can that be used against you potentially? How do you defend against that issue later on? And that's always important to review and understand that.
The way I have it in my mind is an advisor leaves, especially a bigger team. The firm is their first step, aside from redistributing accounts, et cetera, is they want to try to find proof that the advisor, the team violated their employment agreement. And then they'll pursue legal action if they think they have something that a judge will rule in their favor on. Is that kind of the process flow? Or is it that firms really are only keeping an extra watchful eye for big teams or for advisors who left in an adversarial fashion? Like, how does it typically work?
Yeah, it depends. A perfect lawyer answer, but I think you're correct in that larger teams are going to more political type issues. They're going to have more scrutiny, but all the firms will do a detailed review, analyze emails, printings, video camera, talk to people in the office. Are you seen walking out with documents and all that type of thing? So you have to get ahead of that. And at that point, having good defense counsel, if you see a firm starting to move forward with setting up Exhibit A evidences, cease and desist letters, that type of thing that they would use with a TRO, if you have advised the client and the advisor has followed that and done things right, that's your opportunity to lay that out and pat the firm down. And I think a lot of the leverage kind of moves to an advisor who's done it right at that moment, because if the firm files for a TRO and puts it all out there and misses, that's the worst possible scenario.
They're going to try to shoot their shot, but they better make it in at least more than half the time for it to be worth it to them.
Yeah, and in firms who lose a couple of these, they'll look more at the low-hanging fruit. Now, there are some firms, JP Morgan, they're in the news a lot. They're filing a lot on certain bank advisors and things like that. They win a lot of those. We defeat a lot of those, but that's their mentality. That's part of their strategy. So it just depends on the firm.
In your practice and just from what you observe in the industry, do you see more litigation against advisors who are leaving or joining a non-protocol firm? So meaning they're somehow UBS or Morgan Stanley, as an example, are involved. Are those advisors more at risk and you're seeing more legal action against them than someone who's making a protocol move, let's say from Wells Fargo to Raymond James, as an example?
Absolutely. I think that the protocol moves, the litigation over protocol moves are rare and far between. OpenArc, for example, was a protocol move. So the firms that were part of the protocol, like Merrill Lynch, they tried to go after people, and it's just a much harder sell when you're part of the protocol. You really have to show either an exception to the protocol, a contractual
Yep.
exception that's excluding the protocol. Most of the time, we see it in circumstances involving retirement agreements, but the lawsuits, I would say the vast majority of lawsuits are going to be non-protocol lawsuits.
Yeah, it was probably an anomaly that there was the OpenArc protocol TRO that was filed. The whole goal of the protocol is to eliminate litigation, and the individuals would not have liability for certain things. But I don't think that if somebody goes to a non-protocol firm, that the risk is highly increased. I've placed dozens and dozens of folks over the last year or two with Morgan Stanley, and we've rarely had issues there. It's about the process and whether that's done right. Customers, and we'll probably touch on this, but customers have the freedom of choice under FINRA rules, and that's been more codified lately with notice to members and FINRA interpretive materials. And we were involved with some of that back when that first came around. But as long as folks are following the rules with documents in the solicitation, and we're following the customer freedom of choice, and that is primary versus trying to gain some sort of unfair advantage, then you're going to have some protections.
Interesting. In your experience, either with the folks that you represent or just following along with cases in general, when a firm does file a dispute against an advisor in transition, how does the advisor usually fare? Do you give me this like an approximate, like what percentage of the time is the firm successful in getting the TRO? And I guess just any sort of anecdotal or actually like hard data to prove out the concept.
It really depends on the counsel they use. And it's funny to say that, but the more experienced counsel that you have and the deeper bench, so to speak, the more availability, and size does matter, I guess is the easiest way to say it. On a very quick TRO, you need a team to jump on it urgently. And so if you have a firm that has more experience with more resources that can respond to a TRO quicker, you're gonna fare better. And you're talking about recent examples. I think that one of the more recent examples was comparing a TRO that Michael handled adverse to UBS with another one that came out, two teams approximately the same size with the same contracts, and it came out vastly different. And it's not dependent necessarily on the FA. It's dependent more on the counsel that they use and how TROs are responded to. Because if you can get in there really quickly with customer declarations saying you didn't do anything wrong, I'm talking about within one day. And this is why it's sometimes important on a complex situation to have even pleadings pre-drafted. A lot of people don't do that. So if you can get in there quickly with the right evidence and the right strategy, you can minimize the chance of getting a TRO or maximize the chance of the other side realizing, whoa, I might lose this. I better stipulate to something that's not so harsh.
Yeah, it is very fact specific, Lewis, and you need good advice and individuals who follow that advice. But anytime you're in front of a state or federal court judge who may not have familiarity with FINRA rules and how often folks transition between firms and whatnot, it can be a roll of the dice no matter how much you prepare. That recent UBS case that they brought in West Palm Beach, that federal judge had set it for a full evidentiary hearing within, I think, 2 days. So very difficult to quickly prepare that. We were, with the size of our team, we were able to split that up. And because I was up in Atlanta when that was filed, dealing with the OpenArc issue, but the part of my team came down and got everything filed. And we were able to actually negotiate an agreement with UBS. That was what's called a stipulated injunction order, where both sides reserved all their arguments and claims and basically agreed on a course of conduct moving forward instead of putting it in front of a judge who may restrict client movement. That was the main thing that we were focused on, to make sure that clients had the free opportunity to come over. There was no impediment to that. UBS wanted to be seen as defending its retirement alpha program. But if we hadn't got all our defenses in there and there was risk that they would lose that, they wouldn't have come to the table and negotiated what was a pretty positive result there. Whereas, unfortunately, the folks that went to RBC, that judge moved very quickly and they were not able to get all their defenses in. And it's a very one-sided restriction that was issued against them. And now they're fighting off their back. The press is very negative and they may be vindicated. FINRA has a really good process where if a state or federal court judge who may not know the rules somehow does something that's restrictive to the free movement of clients, then there's a hearing with a panel of arbitrators who are familiar with these issues that takes place within 15 days. So we may see more come out from that, and those folks may ultimately be vindicated. But from our perspective, if you can get to a deal that doesn't hurt you and clients can freely move, and avoid preparing for arbitration over the 15 days and work on your transition and build your business, that's always the better result there. So the best litigation result is staying out of it.
Yeah, I think that's a very helpful answer. It also strikes me that we always advocate when we're representing advisors that you have to hire your own legal counsel. There's only so much we can do. Ultimately, they're the ones who pay the fees and they live and die by their decisions. But this is conceptualizing for me too, like why it makes sense to work with an attorney, have the relationship, et cetera. My guess is you can do a much better job defending someone if they are sued for whatever reason. If you know them, they're a client already, you help them with the transition, rather than someone you probably get all the time, 911 call. Hey, I just left, I got TRO'd. Can you be up in Alabama tomorrow?
Yeah, that's a very, probably a negative result that is going to be down that road. But our process, we try to start as early as possible and really get to know the advisors, the team, their background, how they got into the business, their family, what type of clientele do they service, political issues with the firm and management, and anything that they've been dealing with. And we really uncover every stone. We often try to think of every worst case scenario possible, and we have a plan for that. Most of the time it doesn't happen, but when it does, you're ready for it. You're prepared. A lot of times we'll pre-draft the pleadings in state or federal court in whatever jurisdiction. So if somebody files quickly, we can get in there with a defense, and that can make all the difference, both in the legal result and in the press, which is part of the battle anymore. It's getting the business over, defending any lawsuit, TRO, and then winning the battle in the press. So there's a three-front war really that happens here when somebody transitions.
Yeah, and Lewis, I think that what also helps is we're able to see both sides of it, because both Michael and I were outside counsel for large broker dealers. We do both sides. We bring TROs and we defend against TROs. So we know what evidence works and what doesn't work, and what are the best ways to strategize on either side.
Well said. You hit on a couple of recent cases, but are there any other ones, whether related to TROs or just in general around financial advisor employment transitions, that really stick out to you as being an instructive, either is it in a positive way or a negative way? Is it a cautionary tale or kind of words of wisdom from particular cases or matters?
There's plenty, and I'll let Jared touch on a couple horror stories probably, but there's one case I had up in Vermont that I thought was a little bit special this year, and it was really a battle between two trust companies, and it wasn't a FINRA licensed individual, and in that contract, it had a non-service provision where these advisory customers that had relied upon this individual for years were not able to be serviced by him or his new firm for 2 years. And we analyzed that, and it was our opinion that would be difficult to enforce, even though there was no law right on that point, no court decisions in that jurisdiction. They had all their venue in a state court in Vermont. And we decided we would be very conservative, and they're very careful not to solicit, documenting everything, not even announcing, I believe. And if customers wanted to come with us, we would document that and be very clean there. And that went to an actual TRO hearing. And the only issue before the judge was, is that non-service provision itself, is that viable? Or was that against Vermont public policy? And basically, there's a well-written opinion that came out there, and maybe I'll have somebody do an alert on that so you can pick it up. But the judge really analyzed it in detail and decided that an unsolicited customer was free to go be serviced by whoever they want. The policy in Vermont was that not to separate financial advisory customers from their advisor, who is advising under an RIA type umbrella there. But, I thought that was a very important result, defending customer choice. I think that's really important. FINRA has said that's important, and it's something that all advisors and firms need to think about at the end of the day. The customer has the freedom of choice. No one necessarily owns the customer. They can go where they want and shouldn't be interfered with.
Well said. I completely agree with you. That'd be crazy if that was the case, where your trusted advisor, who's been part of your family essentially, is now no longer legally able to service you if both sides are still willing to do so.
It's a tough position to be in if you're a customer.
Yep. Good job. Thank you for winning one for the rest of us.
We always like to create some new law. That's helpful. So,
Jared, anything on the same question that sticks out to you?
Yeah, what's fascinating is a lot of people don't realize is that the attorney space for attorneys who are really highly experienced in this field is not that large, right? So you see the same players over and over. And an interesting sort of anecdote to that is that you get to start to use people's words against them over and over. So you see the same attorney in the same firm bringing actions, and you build up essentially a database of things that they've had to concede to or admit in open court in the past, and you can shove that down their throats in the future. So it's an interesting side note to the fact that there's not so many of us doing this, and you want to be careful what arguments you make, is that could very well come back to bite you later on.
Yeah. Interesting. How about Jared? I think you're just nominated for this question. I think this is my favorite question I'm going to ask. But what are the biggest mistakes or even stories of advisors like really messing up that increases their legal risk during a transition? I know I can share a number that I've seen. I'm not even a lawyer. So I guess one, just as a concept, like what are the biggest things advisors do to trip themselves up legally? And then maybe an anecdote or two on a name blind basis that stick out to you.
Yeah. So the biggest things that I see people make mistakes that can really hurt them are going to be taking things that you shouldn't take. Okay. Your attorney's going to go over your contracts and decide what you can and take and cannot take. Some contracts allow you to take more than other contracts, right? There are some people who have contracts that allow you to take everything. Some firms allow that. And then some firms don't allow you to take a single thing. And so taking information you shouldn't take is probably the one biggest no-no, because you can not only get in trouble with a restrictive covenant, you can get in trouble with FINRA. So an anecdote on that is there's an increase in AWCs, which are acceptance, waiver, and consents, which is essentially a FINRA settlement if you've done something wrong and they investigate you and they decide you did something wrong. So over the last few years, there's been an uptick of people trying to circumvent the don't take information that you shouldn't by doing creative things like mailing a copy of a client statement to every single one of your clients so you can get it after the fact on the back end. I've seen that a number of occasions. And what FINRA has said is that's a violation of the privacy policies. That's a violation of the rules. It's a violation of Rule 2010, which is high standards of commercial honor. And FINRA will fine you and they will suspend you if you get caught doing things like that. So taking information you shouldn't take, pre-soliciting your clients, that's another huge no-no that people get into trouble with all the time. People will say, well, Mrs. Jones has been with me for 20 years and she'll be so upset if I don't tell her that she's got to go. And then anecdotally, we had a circumstance where this little old grandmother who was perfectly loyal to him was told beforehand and called him up one Friday afternoon and he wasn't in the office. And she's like, oh, has he already gone?
Oh.
And boom, all of a sudden you're getting called into the office and potentially getting fired.
It was an expensive lunch break for that individual.
Exactly. Michael, anything to add?
Yeah, I mean, it's trying to cut corners, and gone are the days where people would need to take a bunch of documentation because they couldn't reconstitute it at the new firm. And with all these data breach type laws, customers are more understanding that somebody can't take all their financial information to a new firm, and they're going to be patient, while they reconstitute that. A lot of it's electronic, so it's much easier. And with the pre-solicitation, I think a lot of customers understand that while you're at a firm, you have a duty to that firm not to discuss your plans for leaving, and you can tell them that. You hold your duties high, and however, I resigned earlier today, and you're one of the first people on call to tell the exciting news. So there's lots of ways that you can handle these type of things without putting yourself in violation. And that's a lot of the time we spend setting up those types of scenarios and how you should react to put yourself always in the best situation with that.
Makes sense. What about more on the positive? What are a handful of best practices that advisors should follow to protect themselves before and during a move?
Well, so I'll start with that one. It's hiring competent counsel as early as possible and following what they tell you to do. Not only does that help you sleep at night because you're not worried about getting caught with something, it's not taking things that could be customer information type related unless you're under the protocol and you're allowed to take a list. You don't really need that. You don't need to pre-solicit. You don't need to do things on the way out the door to make it harder for your former firm to. I had one case where somebody had switched phone numbers of clients in the system, and the departed firm couldn't get a hold of folks. And that was a major FINRA violation as well.
Yeah, that was a 30-day suspension, actually.
Yeah,
Oh,
that came back to haunt them.
Yep.
So it's following the rules. And if you do get sued on that with a TRO or anything, you can put forward an affidavit in your defenses that show that you're doing things right and you're doing things so that the customer freedom of choice is protected and you're deferring to that. And even if you're caught up in litigation, the press that covers that can see your side as well, and it's not going to be negative against you versus theft of trade secrets and conspiracies and things like that.
Makes sense.
Basically, just know what you can do and not do right from the start, because you can't undo certain things. If you take action or steps to take information or to violate your contract in some way, it's not always easy to put that milk back in the bottle, right? You can't undo stuff sometimes. Sometimes you can. Sometimes if you've taken things you shouldn't have taken, you can bring them back. And as long as you don't have them at the time you leave, no harm, no foul. But you start taking pictures on your phone of client information, that's a pretty permanent thing that is hard to undo. So know what to do right from the beginning with a plan designed by someone who knows what can happen if things do go wrong, because that's how you can plan to do it right.
And optics are really important here and what the story is going to be. A lot of times our advice over the years, we don't even have people clean out their offices. If it's messy, leave it messy. We'll send movers over to get there with a list to get their items the following week. But if the firm sees empty drawers, even if it's charity meeting minutes that you've compiled for years, the optics of that is there was documents in there. You'll have somebody sign an affidavit that it must have been customer information. And it's about getting ahead of all those little things and putting yourself in the best type of optics and view that you're doing things right. You're not trying to cut corners. So it's a mix of practical and legal advice to always be on the right side of any issue.
It sounds like you've learned probably a lot of these lessons the hard way through the eyes of your clients.
That's one way to learn, certainly. But yeah, over the years, I think there's a lot of war stories, and that helps us keep people straight too, and they can sleep better at night. But most firms have an attestation that somebody needs to sign to get their upfront or something like that they've followed the rules. And I want all my clients to be able to sign that and not have to worry about it down the road.
Wait, I still have a question. This super simple, maybe yes or no, or a quick elaboration. If I'm a big advisor, I'm important, but I follow my employment contract to a T. I retain you guys or a firm like yours early on in the process. I do everything right, everything by the book. I'm a Boy Scout. Do I have anything to worry about as far as litigation?
You can never prevent somebody or a corporation or anybody from filing a claim against you. In America, you can file a claim for anything. It may be frivolous and get kicked out, but you can do everything right. You can plan for a long time and check all the boxes, and you can be a protocol member and like Open Arc and still get a lawsuit brought against you. You can never fully prevent it. You can certainly make yourself a hard target and ultimately win that, both in the litigation and in the press. An ounce of prevention is worth a pound of cure here, but you can never fully eliminate the risk.
And Lewis, you can't also eliminate the human factor. Think about what that departure is going to do to the manager and the manager's bonus and compensation and team and production roll up of the office, right? How vested interest does that manager have in trying to retain those clients? Some of those come into play, even if you do everything right.
Yep. Right. But I agree with you. It's America. Anyone can sue anyone for anything. But if your side of the street is clean, you're controlling what you can control, you're at least putting yourself in the best possible position to overcome any challenges that might come your way.
Absolutely.
Absolutely. And the leverage shifts to the individual if you've done everything right, because now if the firm comes forward with a TRO and misses, everybody else could be incentivized to test that. It's a very negative result there. So putting yourself in the right position gives you by far the best chances to avoid it, but you can never eliminate it completely.
You know what? A good example of that, Lewis, actually is OpenArc. And I know we keep coming back to that, but OpenArc did everything right. And it's why they won the TRO. They spent a long time, a lot of money trying to make sure they did things right. And as a result, they now have potential claims against Merrill Lynch because they did things right and they were sued anyway.
Interesting. And related to OpenArc, I know I don't want to put you in the tough position of talking about it because it's an ongoing matter and it's very fresh. But I know from the successful work you did for the launch of OpenArc, that kind of sparked an idea for you that we should develop a new practice area, the RIA Development Practice Group. Can you touch briefly on what that practice is and what are the services you're going to provide now?
Yeah, thank you, Lewis. We're very excited about this because we don't think any other firm has something with the scope and breadth and expertise of what we have here. And we do a lot of work around the industry with broker dealers as well. And you certainly don't count them out, but there's a lot of folks going independent. And for probably the last 10 years, we have been doing this type of work and bringing in different legal specialties who have developed a lot of expertise in the RIA space. And really the key here is that somebody like myself or Jared would quarterback these type of transitions and make sure that everybody's rowing in the right direction with an eye towards a successful transition and defending any litigation. That's the ultimate goal there. But we've put together an RIA development practice group where it has, I think, 12 different legal specialties, transition services, litigation, corporate drafting, business entities, tax, real estate, trust work, intellectual property, employment law, immigration, data breach. And we've got lobbyists in DC and in various states that are familiar with the SEC and have relationships there. So it's really a one-stop shop where somebody on our team who is very knowledgeable in this area can run it, and everything is taken care of for somebody. They know exactly what to do, how, and when.
What's so exciting about this is that there are so few attorneys who do what we do, who have the 300 attorneys at their firm they can draw upon to create this practice group that's all encompassing to assist in all of these different areas.
Yeah, it's very smart. One of the most overwhelming things for an advisor considering breaking away is all the vendors you have to hire. And I don't even know where to start with doing X, Y, and Z. It's a big part of what we do and various platform providers, be it Dynasty, Sanctuary, LPL, et cetera, help with. But at the same time, to know that you can go to one legal source to help you across the board, I think is a great innovation. I think we're just about out of time here. One last question for both of you. What's a parting piece of advice that you give to an advisor thinking about making a move in the future, aside from hire you?
Well, of course,
Mike,
that would be number one, but follow the rules. If you're a good client, you listen to your lawyer. Usually good clients get good results, and an ounce of prevention is worth a pound of cure in this area, certainly.
and I guess what I would say is it's the most important decision probably of your career. A lot of advisors don't move very often. So take it seriously and create a plan and don't be cavalier about it because for many people, if you do it wrong, your career could be devastated.
Yep. I'll add one too, which is don't be cheap. A number of times I've had very successful advisors say, hey, I don't want to pay X thousands of dollars as a legal retainer because the firm I'm going to is hiring me counsel, or my brother-in-law is a divorce attorney, or my contract's easy, it doesn't matter. I always see that biting people in the butt. That even if nothing happens, which you hope for, it's a worthwhile investment. It's an insurance policy to end up on the cover of a trade publication or to have a very costly ongoing litigation dispute.
Yeah, you're 100% correct.
Thank you both for being gracious with your time. I don't think I'm gonna get a bill in the mail for an hour of your time today. But in all seriousness, just hearing I think a very real, non-jargony kind of explanation of what's going on across the industry, just tracking some real cases, real experiences, has been eye-opening for me, and I know for our audience as well. So thank you both for joining us today.
Thanks for having us.
Thank you.
As a financial advisor, you hold yourself to the highest standards of integrity, honesty, and credibility. You are successful because you take your professional responsibilities seriously and are dedicated to your clients. But are you living your best business life? Are your goals aligned with your firm's, or could a better option exist? Should I Stay or Should I Go is a book written with you in mind. It's a self-guided journey that walks you through the key steps that we take with our advisor clients. This strategic thought process and roadmap to professional self-discovery is designed to help you ask the right questions and think critically and objectively, whether you're considering change or not. Learn how to get your copy at diamond-consultants.com/thebook.